So as I was saying, the topic today is privacy policies and terms of website use, best practices under California and federal law. Our speaker today is Heidi Klein. She's an attorney here at Royce Law Firm. She practices in the area of trademark intellectual property and spends quite a bit of time drafting terms of use and privacy policies. We have written materials. Well, we will have written materials for anybody who wants them. We've got them up on a screen. You should be able to see them on your computer screen. If you have any questions during the program, go ahead and type them in if you're listening by webinar into the dialog box in the right-hand corner. We'll collect them towards the end, and Heidi, and we'll respond to them to the extent that we have time. Okay, Heidi, terms of use.
Hi. First, thank you for all coming and listening. And this is, I've spent the focus more on best practices and advising clients, because a lot of times with terms of use and privacy policies, the clients will just come to you and have you review their own. And so a combination of the law that has been developing around it, and then also the best ways to address client concerns and questions. We'll start with terms of use, and then we'll go into privacy policy. Okay. So overview, the biggest concern in terms of terms of use is enforceability. Whether you use browse wrap, click wrap, scroll wrap, all the different types of online agreements that have been provided for different website service providers, enforceability is the biggest issue that we face. So to address some of those, the courts have looked into the presentation of the terms of use and adequate acceptance, modification and changes subsequently to those terms of use, the enforceability of certain material terms, and then there's special considerations for e-commerce websites and social media platforms. So a couple cases recently, last year in 2014, and then another one just this last summer, have touched on the enforceability of browse wrap agreements. So Winby Barnes & Noble, basically, their terms of use were provided at the bottom of their website in bright green, and it was on every page. The user here did not have actual notice. So essentially, enforceability depends on whether the user has actual or constructive knowledge of the term. Courts have consistently enforced browse wrap agreements where users have actual knowledge. So the real issue here is inquiry notice, and the question there, the general rules, terms must be sufficiently evident to make a reasonable, prudent user aware of their existence. And the court in Wynn pulled out 3 factors that they look at as to whether or not they would be put on notice of it. The general design of the website, whether the link to the terms is conspicuous. They look at both the visibility in terms of color, presentation, and then also the placement of the link. And then whether there are any other notices provided to the user regarding the terms and where to find them. Generally, inconspicuously placed terms tucked away or buried in the bottom of the pages are unenforceable. Finding a multi-step process, having to go through a multi-step process to locate the terms is unenforceable. On the other hand, courts have found it sufficient where websites implement explicit notice that continued use will act as acceptance and consent on each page that you go to. So as you navigate through a website, if there's a notice at the top to say, you are, by using this and continuing to use this site, you are subject to the terms and conditions with a link to the term. So in the most recent case, although it's a New York case, Berkson v. GoGo Inc., they defined an additional type of adhesion contract in the internet world, the sign and wrap agreements. But again, we go through the browse wrap agreements where essentially that just, you're bound by them by using the site. Click wrap, where they have to affirmatively click a box. Scroll wrap agreements, where you have to go down to the bottom and you find an I agree button there. And then sign-in wrap, where there's no requirement to click or accept the terms of use through an individual box. It simply includes a statement that by signing up, you agree to the terms of use and privacy policy. So when we're looking at acceptance, some of the things that we incorporate into our terms of use depend on, it obviously depends on the service that you're providing. Facebook, won't have eligibility terms necessarily because they offer their site to minors. But for most websites, especially e-commerce websites, we generally include a term where users are consenting and agreeing and acknowledging that they are legally competent, both in age and mental competency. So including a provision with reps and warranties, and then also including that the website provider's right to terminate this agreement if you do not fit into those eligibility requirements, and that if you do continue to use the site, you have no obligation to them, to the user who is underage. Another issue that comes up is subsequent modifications and changes to the terms of use and how to adequately put the users on notice. Blanket statements granting rights to unilateral changes of terms with or without notice is generally unenforceable. So the best way to handle that is providing prominent notice on the website for any changes. So if you make a change to the website, you go onto the, I think Spotify just recently did this, and it pops up all the time, and it says we have recently changed or updated our terms of use and privacy policy. And they'll continue to bug you throughout the use of it. I keep clicking out of it. I don't ever go to look at it, but they will continue until you go there, until you click on that link. So providing the prominent notice, and then in addition, for material changes, sending an email to the designated email address in the user account. Obviously, if you don't require your users to register an account with the website, then you're not going to have an email address. But providing those prominent notices on the website, that can help put them on notice as well. And then including in, the effective date, last updated, so and so, so that if someone does go to the terms of use, they can see that they have changed. Okay, material terms. Right, clear and conspicuous. And a lot of this stuff will just be similar to any type of contract language. I mean, terms of use, you're entering into a contract. So, whether, the offer, acceptance, and consideration all applies, right? And material terms must be conspicuous. And a lot of this has to deal with the relative bargaining powers of the parties. And the reason that these terms are so much, the courts are hesitant to hold them effective is because there's no negotiation, there's no bargaining power on the part of the user. So making sure that these terms are clear and conspicuous and they implement all of the requirements for any type of adhesion contract is your best bet. The court in Bergson said the terms of use must clearly draw attention to the material terms that would alter what a reasonable consumer would understand default rights to be in an online transaction. So, for example, arbitration clauses include clear language at the beginning of the terms of use, putting the user on notice. Right? These terms contain an agreement to arbitrate in this section, and this is how it can limit your rights. Governing law and venue, restrictions on class actions, payment terms, and most specifically in the case of auto renewal. Bold, all caps, maybe not all caps, but making sure it's not, payment terms, a huge paragraph, and auto renewal is halfway in that paragraph. Those terms have been held to be unenforceable if the user wouldn't, you're scrolling down all the way to the bottom and these material terms are all located there. And we come into some special considerations for e-commerce and social media. I bring this up because certain standard agreements, as we were, earlier when we were talking about, click wrap or browse wrap and whether things are enforceable. Browse wrap agreements where you just are bound by them by simply using the website are generally unenforceable against individual users. On the other hand, they have been found to be enforceable against companies, so business-to-business service providers. I have had clients ask if they want to do the scraping and pulling some information from the website, and clearly that's generally a breach of the website terms of use. And they have said, well, we didn't read the terms of use. Okay, you would know that there are terms of use governing your website because you likely have terms of use as well. So again, the material terms that come into play for e-commerce website, the payment term, and then you need to include the appropriate risk allocation provisions, disclaimers, liability, and then limits of jurisdictional application depending on, sometimes, these limitations of liability and warranties may not apply to you as a consumer under your specific jurisdiction. So, and then you have social media platform where you're getting user-generated content. There's been issues over who has ownership. Again, because there's the inability on the most part for users to negotiate their rights under these contracts, courts have found that if there's any language of ownership of the user's content, that's generally invalid. So when you're drafting these provisions about ownership, and especially related to user-generated content, you want to make sure that you use licensing language. You have a license to use their content, but avoid the assignment ownership language. And then again, make sure you have prohibited content in there. Make sure, you're not allowed to put in offensive, violent, spamming, infringing content, content about minors, so on and so forth. If you've looked at Facebook, Instagram, any of the social media websites, if you've gone to their website terms and services, it's just this big, long list of all the things that you can't put up there. And then goals for e-commerce and social media platforms, and any type of website that allows users to put in comments, upload their content, even if it's chat boxes, or comments to, when you go to Huffington Post, you can provide a comment on there. You want DMCA provisions, which is a safe harbor for any, which limits your liability and will negate your liability for secondary infringement if you are posting infringing content. The most important thing to remember and to advise your clients here is that they must register with the Copyright Office and their DMCA agent.
I'm sorry, what is DMCA?
The Digital Millennial Copyright Act. So there's basically several requirements. If you see that it's a provision and you put it on your, as one of your provisions, if you find that someone is posting infringing content of yours, you contact their designated agent and say, this is my work, this is the infringing work, and a statement to the effect that that all of these statements are true, and then they have to remove the content. There's the recent case, the Lens case, where her child, she posted a video to YouTube. This doesn't necessarily affect drafting the terms of use, but that decision has now stated that fair use must be considered by the copyright owner. So it doesn't necessarily affect the website provider, but that's something to keep in mind when people are making those, when they file a DMCA request with the website provider. And so the takeaway for terms of use, analyze the client's business, services, and potential liabilities. Same things you would do in a contract. Make sure you understand the business terms. If it's a simple information website, like for example, a law firm that has services provided, their practice areas, but there's not really much more than that. Your terms of use can be very simple and straightforward, if at all. And there's no requirement to have terms of use on a website. But then review samples of terms of use with similar services to see if there's any special provisions, and try and figure out why they would have something in there that you normally wouldn't see. Customize, taking into account the first two issues, and then implement click wrap or scroll wrap. Make sure that when you have these e-commerce, social media, when there are more responsibilities and obligations on the website users, that they do have to actually accept, and there's a way for you to know that they have done so. There should just be a click to and accept, either through account registration or before payment. If they're going to do anything that collects personal, or they're agreeing to personal information, which ties into the privacy policy, but anything where they're collecting personal information or financial information or making a payment, where there's a real back and forth contractual obligations happening here, there should be click to accept in those two, at some point before they engage in those activities. Again, clear and conspicuous material terms, and then clear notification when there's any subsequent modifications or changes to those terms. Okay, so moving on to privacy policies. So we're going to talk a little bit about the Federal Trade Commission and then the California Online Privacy Protection Act. Federal Trade Commission has said it's necessary to avoid unfair and deceptive trade practices. And then, obviously, the California Online Privacy Protection Act was the first law that implemented a broad requirement for privacy policies, and actually requires privacy policies for any businesses collecting information from California residents. So essentially, any website in the United States. Generally, the kind of going over the two things that the FTC will look at, deceptive and unfair trade practices. So the FTC considers the breach of a promise as a deceptive practice. And two of their kind of landmark cases, which are clearly older but have paved the way for the way that they handle these cases currently. In the matter of GeoCities, GeoCities had an online community where users could maintain personal home pages. Their privacy policy promised it would not distribute or sell any collected information. And then the FTC alleged that GeoCities misrepresented how it would use the information because it actually did resell the information to third parties, which was in violation of their privacy policy. In these cases, the FTC will generally enter into a consent decree where they admit that they were wrong. They get posted up onto FTC's wall of shame, and then they have to implement, the privacy policies. They get external audits by third parties for some amount of years, and as long as they are in compliance with those, then they're, no longer under the watch of the FTC at that point. In the matter of Microsoft Corp, on its website, Microsoft claimed that they had a high level of security used to protect the personal information that was collected in their Passport website service, and this service allowed single sign-in for multiple website services. And then the FTC alleged here that these high-level security representations were misleading because Microsoft vendors and business partners were the ones who were actually controlling the information and not Microsoft. So the FTC essentially said that because Microsoft represented that it was the one with the high level of security, that was deceptive because the business and vendors of these other website services that they were signing into and would be providing their personal information to, they were the ones in control. As for unfair trade practices, FCC has stated the practice is unfair where the injury caused is substantial without offsetting benefits and one that consumers cannot reasonably avoid. And so there's two cases on this where in the matter of Gateway Learning Corp, they had, it was at Education Services, and they stated they would not rent, sell, or loan any personal information without consent, and if they changed their practices, users would have an opportunity to opt in or opt out of the collection. So Gateway then started to sell the information, and retroactively, they modified their terms to allow them to sell and rent and use that personal information, and that they didn't have to provide users notice for that. And so the FCC stated that retroactive application of material changes to the privacy policy was an unfair practice. And then in the matter of VJ's Wholesale Club, VJs failed to encrypt personal and financial information and failed to secure wireless networks to protect unauthorized access. Now, their privacy policy said that they used these practices. They weren't deceptive or misleading about what their data protection practices were, but failing to implement basic security controls to protect consumer information constitutes an enforceable unfair trade practice claim without any need for the FTC to allege deception. So, because encryption is such a reasonable and widely used industry practice for personal and financial information, you should always use it. The California Online Privacy Protection Act. So this applies to operators of commercial websites and online services that collect personally identifiable information about California residents. And some of the requirements, they must conspicuously post a privacy policy, and they must comply with that privacy policy. So online service includes websites, mobile apps, desktop apps, Facebook apps, software as a service apps, and any other platform where users would share their personal information. And personally identifiable information is broadly defined and includes information about a consumer collected online and maintained by the operator in an accessible form, including first and last name, home or other physical address, street, name, town, email addresses, telephone numbers, social security numbers, pretty much any information that you can identify an individual from. The other thing to keep in mind here is that even if, for example, certain records where people will include personal information within this list may be public information elsewhere, but it doesn't necessarily mean that it wouldn't be considered public information under these circumstances. So just because someone, for example, let's say there was a lawsuit and the court records are public, just because that information can be found there doesn't mean that the information that they give you is allowed to be public. So that's something to keep in mind. And then additional requirements. The categories collected must be clearly defined and of how it's used. And then, is this in that? Oh no, I got that in there. Sorry. And then the categories of which third parties that the operator will share the personal information must be listed. The description of process for a user of the site to review and request changes to their personal information. And then description of process notifying users and visitors of material changes and the effective date of the privacy policy. And then additional requirements depending on what type of information is collected. We have the Children's Online Privacy Act. So any personal information that's collected from children under the age of 13 will pretty much invoke COPPA regulations and obligations on the website provider. If your website isn't designed for children under 13 or 18, I mean, we generally say, with the terms of use, that if you're under 18, you shouldn't be using this site. And then a disclaimer along the lines of we do not knowingly or authorize any collection of children under the age of 13. You know, if we find this information, we'll immediately delete it. If we know that you're posting information about children under the age of 13, we may terminate your account. And if you see any information or know of anyone, please let us know immediately. There's also the California Shine the Light law, where if...
Question about that. So what are the rules, though, for handling some sites, obviously, that do have information about kids?
Yeah, so that pulls into, essentially there's parental, it invokes a bunch of parental consent obligations. And then the best practice for that is there are several ways that are acceptable to get consent from the parents. Usually an email or a phone call, you have to get the parent's address, and they can either email back their consent or fax back the consent with their signature. Simply having a button that says, I am a parent and I accept this, right? Then, you know, when the child is signing on, registering this, it's unacceptable. It doesn't work. So COPPA pretty much covers parental consent and the guidelines in getting proper approval from the parents. And then the Shine the Light law, if you are selling information for marketing purposes, if the California residents request so, you need to tell them what information and with whom it's being shared to for those marketing purposes. And then the Do Not Track law. Again, there's not really...
Question on Shine the Light law. So if you have a website with a number of subscribers and they're all getting certain kinds of information, and you would like them to get some other kinds, quite different, non-commercial information, you need to send a notice around to all of them saying we intend to provide you this information. If you don't want it, please let us know, or something like that. How would you do it?
Yeah, and this is the Shine the Light law. I think, well, so in that scenario, if you think that the information you are sharing would be something relevant to their use of the site or the reason that they signed up for it, then you can add that in your privacy policy. We may send you additional communication. You can always opt out of this, and you can either do, and then explaining your opt-out procedure either through email or a box or, in the unsubscribe link. We've probably seen, a number of different methods for you to unsubscribe from additional communications, whether it's marketing or other services provided. And another note on the opt-out, generally what we add in, I think I might cover this a little later, but what we'll add in their choices about what type of information they want to receive, including a statement that communications about your account or your use or changes to our privacy policy you cannot opt out of, because they are essentially opting out of things that you are legally required to provide to them. So, but opting out of marketing and non-related communications to the service provided, there should be an opt-out option.
So when you send like an email or something, you include it in the heading opt-out provisions.
Exactly.
Okay.
Yeah. And then, but the Shine the Light law is when you're selling your information or their information to third-party marketers. So you have to, when you clearly set out how that information that you collect is shared with third parties, and if you share that information for marketing purposes, in California residents, or if it's California residents information, so even if a website located in Texas was sharing information with marketers, but it's collecting California residents' personal information, we have the right to go and request that we know what information is being shared and with whom it's being shared to with these third-party marketers. And then the Do Not Track. There's no, we now have these Do Not Track beacons, and there's no requirement of how we have to respond to them, whether or not we have to, stop tracking them. We just have to let them know what we do when we get one of those requests. So it requires new disclosures, and the first is if so the operator's response to a browser do not track signal or to other mechanisms. It's required when websites collect personal information over time and across third-party websites. So essentially, if you're not tracking your users, this isn't going to apply. Sometimes people just and with the personal information, right? So anything that falls under the personal information. There's, I believe, Google Analytics will, I know they have quite an extensive tracking program, but sometimes you can just have a visitor counter, and that's not, that wouldn't be considered personal information because all it is a number. It doesn't say who's coming from where, or what website, or what they came from, or where they're going. So if you are really a passive website that is just providing information and you are not tracking them, then you do not have to provide this disclosure. And so if you don't, if the website provider doesn't have a procedure to respond to the do not track request, it can be satisfied by saying, you link to a program. AllAboutDNT.com has a nice little blurb, and they have all this information on developments on the do not track procedures, and you can just put that right in there. Say something along the lines of this, this is a do not track is in development, and there's no clear procedures on what we do or do not have to do at this time. As of now, you can learn more about it at allaboutdnt.com. And then the other one is the possible presence of other parties conducting online tracking. So if you're a website that, if there's a lot of advertisement on your website, then there's the potential that third parties are tracking you coming to this site. And so a simple disclaimer of, third-party websites may be tracking your location coming to here. We do not collect that information, but this is, something that exists. So a really good source, and I, refer to this a lot, but our Attorney General has, put out a publication of making your privacy practices public. And to kind of put it in perspective, we say privacy policy here all the time, and it's interchangeable with privacy notice or privacy statement. Privacy policy is typically the internal privacy policy and activities within the organization, and the privacy notice or statement is what is put out to the public in terms of explaining to your users and visitors or consumers on your privacy, on your information collection and retention practices. So some advice here is readability. Use plain, straightforward language. Avoid technical or legal jargon. You use format that makes it readable, such as layered formatting. Online tracking, do not track. Make sure it's easy for a consumer to find the section. Label it, make it clear, put it in an entirely different section. I think several websites will have a section for California residents alone. And then that's where you can put in the shine the light law and then the do not track. And then describe how you respond to that signal. And then it's more transparent than linking to choice of program, right? So state whether other parties are or may be collecting that personally identifiable information of consumers while they are on your site or service. Data use and sharing, explain your uses of personally identifiable information and what's necessary for fulfilling customer transaction or for the basic functions of your service. Whenever possible, provide a link to the privacy policies of the third party with whom you're sharing personally identifiable information. One of the most important things I found for websites where you're collecting financial information, I mean, industry standard is to use third-party payment processors so that you don't have to deal with all of the financial regulations. So listing out generally what I would put in mine listing out the actual third-party payment processor, so PayPal, right, and that's, or Square, whichever one, but listing out the one that you do, and then putting in a link to the privacy policy and stating clear that you don't have control over it, but please go make sure that you read their terms of service. I have noticed too that most of the time when you get to the point where you are completing a transaction, that the PayPal terms of use and, or whichever that payment processor will include a link to their terms of use there, or their privacy policy, within their, because usually it's included through an API. And then the individual choice and access. So describe how the choices the user has regarding the collection, use, and sharing of their personal information, whether they can opt in, whether it's an opt-in or opt-out situation, where opt-in requires the user to actually affirmatively consent to the collection and sharing, whereas opt-out, they already, we're going to collect and share it this way. If you don't want this to happen, you tell us.
And both are legally acceptable.
Yes. Except for when you change collection, it needs to be an opt-in situation. So if you're going to change the way that you practice and collect user information with personally identifiable information, then you need to make sure that you get the opt-in. So send out a notice. Opt-in can be if you continue to use this site after you've been put on notice of this, you're consenting, to the use. But and then they can always opt out later as well. So accountability, clearly tell users whom they can contact with questions or concerns. And then in addition, these are just some extra things. Incorporate by reference into the terms of use so that you can include the risk allocation provisions without overcomplicating the privacy policy. You want your privacy policy to be short and clear. Terms of use can be long because there's a lot of general stuff that's going to be in there, and as long as you're pointing to the material terms, they'll remain clear and conspicuous. I like to include clear consent from the user. So nice statement right at the beginning of the privacy policy after we've discussed that it's incorporated into our terms of use. By submitting the personal information to the website, you agree to the terms of this privacy policy, and you expressly consent to the collection, use, and disclosure. If you do not do so, do not use the site, do not provide us personal information, so on and so forth. And then implement reasonable security measures and explain those measures in the privacy policy. And so again, analyze and fully understand the data collection and retention activities of your client. We like to having a questionnaire or having a list of questions that you can ask to figure out whether or not any of these special considerations apply, whether they should implement extra security provisions depending on the type of information. There's certain regulations. Obviously, medical information is covered by HIPAA. You've got your financial obligations, and so making sure that you understand if any of those special regulations are going to apply to the collection and use. Carefully craft the privacy policy to clearly and conspicuously and adequately explain the privacy practices. Implement your reasonable data security measures, encryption at the very least, and then provide opt-in consent when changing the way personal data is collected, and most important of all, adhere to the privacy policy so that you don't invoke the wrath of the FTC. And that's it. Well, that's good. Okay.
Why don't we take a few questions here? Questions from our group?
I had a question. You mentioned that a business-to-business transaction over the website, i.e. even just simply looking at a website, has essentially a more binding standard than a consumer to a business viewing of a website. How recent is that case law? And the reason I ask is I was involved in a case about 5 years ago in which there was law to that effect. Is that the same law, or has it been changed?
I'm sorry, can you just the very beginning of the,
Okay.
what was the?
If a consumer looks at a business website,
Okay.
there's an issue of adhesion,
Mm-hmm.
there's an issue of knowledge, so the consumer likely is not to be bound
Right.
by that. But if a business looks at another business's website, that business presumably is more sophisticated and is more likely to be bound than would be the consumer.
Right. Yes.
Okay. That law, has that changed in the past 5 years?
Not that I know of, because what they're looking at, in terms of adhesion contracts is, well, there's, bargaining power, and then there's also essentially, because actual notice, obviously, if there's actual notice, then they're going to be bound by the terms. But for inquiry notice, it's whether a reasonably prudent consumer would know. But then on the business side of it, would a reasonably prudent business, individual or, corporation or another website provider know? And now, almost every single business has a website. Almost all of them know about the terms of use and privacy policy issues. And so they would know that they're, I need to look, for these. And again, when you're just a passive website explaining the services that you provide or information about your business, the browse draft agreements are going to be fine, where you're going to be subject to the terms of use, because there's not a lot of back and forth or activity by the user on the website. But when you're, going through more consumer transactions, then that evokes more activity from the user, but businesses are going to know that there's terms around this. So they have generally been enforced against businesses browse draft, without the click to agree.
Has there been any change in the case law in the past 5 years on that?
Not that I know of.
Okay.
Yeah.
The same rules apply to mobile applications?
To mobile applications, in terms of business or the browse draft, and yes, yeah. So, so think of it, best practices. I would always, in terms of procedures and having users accept, I would look at Apple. Right? Apple has you get an update on your phone, right? You have a new update, you accept our terms of use, accept, and then they have this long list, scroll down all the way, and you press accept, and then they have another thing that comes up. I think you have to click through 2 to 3 times of accept before it'll move you forward. And I think I've tried it both ways. I scroll to the bottom and then press the accept button, and then there's another button that comes up, and I think I've also just I agree, and then another, I accept button comes up. So they have multiple levels of you accepting, so that there's no issue there whether or not, you apply, that you have accepted or not. Yes, so for mobile, that does count as well. And something to keep in mind for mobile applications is having it emailed to the user, because if you're on your phone, it's really hard to read through those terms clearly. Sometimes they'll automatically email it to you, or you can request to email it, or they'll tell you where you can find it on their website or elsewhere. And then even for websites, sometimes business-to-business websites they don't put their terms of use online, because it's much more of a business contract than just a passive user. So software as a service program, where one business is offering, whatever service, whether it's team management, building, or report analyzing, whatever they're doing through their service, they'll keep those terms of service confidential, but giving access to those terms of service or being able to print them out is really important. And the courts will look at that as well. I think there's a question here, but okay. Yes, don't most websites put the link to terms privacy at the bottom? Yes, that is true. And that doesn't mean that they won't be held enforceable. So, for example, let's say, because like Amazon, right? It's not like you sign on to Amazon.com and it says you can go no further unless you read our terms of service, because there's different levels. You go onto Amazon and in the beginning you're just browsing, you're just looking through the information, and I may or may not purchase, anything at all. And so how you kind of move through those different steps and levels of when, the terms of use are really going to be at issue of whether they're enforceable or not, is when it gets to the point where I make a purchase. So you go forward and you say, okay, I actually do want to buy something, and you either register an account or sign in as a guest. When you register an account, they generally have a click to accept, as you're going through the account registration process. When you go through as a guest, they'll put it next to, okay, you have to click a button to say you have read our terms of use and privacy policy before making this purchase. And so as long as when it gets to that point, there's a clear ability and acknowledgement. If you're going to have that click to accept, write it, check out, or as they're going through the payment process, you want to make sure that you can log that they've actually gone to the terms of use and privacy policy. If it's simply it's something where by signing up or by signing in as a guest, you agree to our terms of use and privacy policy, even with links there. That's what the Berthson case brought into play, where that's this like sign in or sign up acceptance, and that's inadequate. So you have to because there's no way to know whether or not they've actually read it, and the terms of use will need to pop up into a different screen or pop up on the screen, and then that usually is sufficient to bind the consumer to those terms of use.
Would it be sufficient in a professional services website sounds like it's not sufficient to have just a button at the bottom clicking on terms of use. So maybe a button at the top giving an option?
Yeah, it could be at the top, and if you so if you put up at the top of the website, if there's sometimes they will at the top of their website have something, and I think I mentioned it in the Wynn case where they were going through all these different types that have been and have not been held to be enforceable. At the top of every page that you move forward in, it says, by continuing to navigate through our website or using our services, you agree to the terms of use and privacy policy with clear links to those. So the lookup, generally what they look at is the general design of the website. And a lot of people do put that at the bottom of the page, and some courts have held that if you sign on and you can see it at the bottom of the page, then that's conspicuous enough, as long as it's not a tiny little link hidden somewhere and in like white against a blue background. Make sure they can see it's a link and they can see that it's there. The problem is that when you're looking on your phone or you're looking on a laptop versus a desktop or however big your screen is, sometimes you don't, it doesn't show the same way, and someone will have to scroll down. So having that notice up at the top of the page, if you're not going to have them do a click to agree, or it's not necessary for them, depending on the services that you provide, that would be a very good way of putting those users on notice of the terms of use.
How well does the Wayback Machine stand up as evidence?
Sorry, come again?
How well does the Wayback Machine stand up as evidence?
I'm not familiar with that.
Oh, Wayback Machine is a website that attempts to capture all of the web periodically.
Okay.
And I've gone back, and there's some sites it checks every week, some sites it checks every 3 months. It's been up for at least 5 years.
Okay.
And the question is, how well does that, maybe you don't know it, but what I wonder is how well that stands up in evidence. So like if two people are suing each other on terms and condition either or both might want to go to the Wayback Machine and say what were the actual terms,
Right.
what was the, what was the link, and presenting that as evidence.
And presenting it. Yeah, well, it's any type of, I mean, essentially it'll just be whatever evidence you can pull in to show what the notice was at the time that the user was, at the time that the user was using that website. Yes, that's all. Because you need to know, they're not going to look at how the website is structured now, essentially, if it's different. So, yeah, the evidence would hold up. I mean,
Who knows?
yeah, right. Who knows? Because then it would be, then you'd have to pull in records of, are they actually changing it and how accurate have they been pulling this information and how consistently do they, but generally the companies will have that information.
There's probably,
Is that reasonably subpoenable? What did your website look like 18 months ago?
Certainly from the user or from the website provider, I do not know whether it would be subpoenable from the Wayback website.
But if there's a litigation in terms of what was displayed on the website and what were the terms, could the plaintiff, could the consumer likely succeed in subpoenaing
That would
the
be
provider? Would it be available? The question is,
would it be available?
That's the question.
Well, again, it would depend.
Is it available?
Yeah, it would depend. You maybe if there was a dispute. I think most of the cases that I have gone over, there hasn't been a dispute in fact, which is very interesting because there's no dispute over what was provided on the website at that time. And so there hasn't been an argument over whether, there was or was not a conspicuously placed terms of use or privacy policy link.
okay, we're at the top of the hour, so I'm going to go ahead and conclude the webinar. I want to thank you, Heidi, for giving us this presentation. Thank you, folks. We'll have the materials, a recording of this will be available on the Royce Law YouTube site, and these materials will be available on SlideShare as well as on RoyceUniversity.com. So with that, oops.